Okay, I'm going to get started. I know there's people trickling in and food and all that stuff, but we've got a whole group streaming, so I would rather, and we've got lots of stuff to get through, so I'd rather just go ahead and get started. Just a couple of quick housekeeping things. If you need to use the restrooms, they're right through here. Of course, there's food in the back, so please help yourself. Hopefully everyone found parking out there. I know sometimes they get annoyed if you park over on this side. So if you did park in this row of spaces over here, you may want to move your car. We typically do the lunch and learns from 12 to 1, but because the legal update tends to sort of drag on, there's generally a lot to talk about, we extend this one out. So it will go until 1:30, but if you need to leave to go back, I certainly understand. So don't feel bad about that. If everybody got a copy of the materials, hopefully, I'll just dive right into those. They were in the back, and if you didn't get them, just let me know. I can have Kelsey bring some over. What this basically is, for those of you who have never been to a legal update, is a just sort of snapshot of what happened last year from, whether it's new laws or new regulations or new developments in the courts and case law, to give you an overview of sort of where things are headed. And new things you need to do, new things you need to watch out for, and that sort of idea. We're not going to talk about everything that's in here. I'm a fast talker, but even with my fast talking skills, we could not get through all of this in an hour and a half. That said, I would certainly encourage you to read through all of this. A lot easier to read through a 40-page update than it is to read through each one of the cases that is in this update. That's what I spent all of my Christmas break doing. At any rate, the stuff that's in here truly is basically like free legal advice. Okay, each one of these cases you can imagine cost anywhere from $200,000 to $300,000 probably more than that, since a lot of them have been appealed over and over and over. And so somebody paid a lot of money to get that answer that's right there in that little paragraph for you. Okay, it's definitely worth a read. I know when you flip through this, it just looks like case names and these are sort of these obscure things, but these are actually real people, okay, real businesses, just like you guys, just like me, just trying to stay in business in California. And they've ended up in the legal update. The goal for every employer or for every one of my clients is to stay out of the legal update, okay, because once you end up in there, even if you're in there under the heading, yay, employer is fabulous and didn't do anything wrong, okay, you've already lost because there's a lot of money, a lot of time, a lot of energy, a lot of stress that comes with one of these cases. So you can learn a lot from the mistakes of all the people that have gone before us, and that's basically what this is. It's a compilation of, shucks, I wish we didn't do that, okay? So it is worth the half hour it would take you to thumb through this. If nothing else, it will cure you of insomnia, I guess. So the materials are divided basically into two sections. There's a legislative update, and that just covers the new laws, okay, new things that have become effective January 1 of this year or are going to become effective in coming years. The second section is all the case law, okay, and those are divided by topic. So we have cases that dealt with hiring issues, cases that dealt with termination issues, cases that dealt with leave of absence issues, whatever the heading might be. And I've tried to sort of organize them that way so that there's a little bit of organization to this, because there are a lot of cases and a lot of different issues that this update addresses. I'm happy to stay after also for questions, or if you have questions, feel free to raise your hand. If I gloss over something that you wanted a little more information about, you can grab me after or just flag me down. Okay, so I'm going to start with the new laws. This is the legislative update section. The first one, AB 10, this is the increase to minimum wage. Okay, hopefully everyone's aware of that. It's going to go into effect July 1 of this year. Okay, it's going to increase our minimum wage from $8 an hour up to $9 an hour. And then it calls for a second increase on January 1 of 2016. And then it will go up to $10 an hour. Okay, puts us sort of on step to have one of the highest minimum wages in the country. Not a big surprise. Good old California, leading the way for everybody. One of the things you want to think about, though, when that minimum wage gets bumped up, there's sort of a ripple effect, because that minimum wage baseline, it impacts a lot of other laws. The minimum amounts you can pay in order to qualify for the exemptions, amounts you need to pay for split shift pay, things like that. So just be aware of the fact that this is maybe going to impact other areas. Okay, and then certainly if you've got people who are making minimum wage, make sure you account for that when we get to the summer. I'm going to skip down to AB 241 and the bullet point below it, expanded protection for home health care workers. What happened was I was getting a lot of questions about this. On the federal side, we have protections for what they're called in-home workers. Okay, and these are basically like personal attendants, people that live in the home, go in to take care of somebody who's housebound. All right, and they said, well, if you're a 24-hour live-in, in-home worker, you're going to be entitled to overtime if these certain things apply. They expanded what it means to be a companion. Okay, they cut that back actually, so that now you can only do these certain little tasks. And then they said if you're hired by a third party, okay, like an agency, a staffing company or somebody, and you work for them and they send you into the home, you're going to now be entitled to overtime. Those were the federal protections, and they don't go into effect until January 1 of next year. Okay, so that sounds really good, but not to be outdone, in California, we now have our own protections, okay, and they went into effect January 1 of this year. And what they basically said, and in California, we have what are called personal attendants, okay, and they basically said, look, if you're a personal attendant, unless you're hired directly by that homeowner, okay, and you're in that house, or if you're a casual babysitter, I guess you're exempted, you're entitled to overtime if you work more than 9 hours in a day or more than 45 hours in a week. Okay, they basically just got rid of the personal attendant exemption. Okay, you might be getting a lot of little, I don't know, Twitter update, things like that. Oh, personal attendant, oh, in-home worker. Doesn't go into effect until next year. That's not true for us in California. It went into effect for all intents and purposes this year because the state law changed. If you've got, and I have a lot of clients that have this, that sort of 24-hour care. If you've got somebody who's going to be, typically was on a 24-hour schedule, there are different ways you can sort of carve that up to, cut down on your overtime costs. You may have, 3 8-hour shifts. You may have an 8-hour shift and then a 16-hour shift where you deduct 8 hours for sleep time. There are some different things you can think about to get around this a little bit. You want to probably talk to an attorney or have somebody, look over your policies and your staffing for that. But there are some things you can do. Okay, it's a big hit for employers. By the time that federal piece goes into effect, January 1 of next year, to give you an idea of what a big hit this is, that's an additional 2 million people that are going to be covered now under these overtime laws. So there's a lot of money at stake, of course, which is why we get these new laws. So somebody else can get a lot of money, yeah. On the next page, and I'm at the first bullet on page 3, this is SB 435, expansion to heat illness recovery periods. What they basically said, and this isn't one that's gotten a lot of press, but potentially, especially for us in Bakersfield Central Valley, where we've got a lot of outdoor workers, is potentially a big issue. When somebody feels like they need a cool down period, okay, they get to go and stop work and have this cool down period. And what this law says is you can't require them to do any work while they're having that cool down period. It needs to be no less than 5 minutes. There are some certain things you need to do. But the key with this law is they can't do any work when they're having that recovery period. Okay? And if they do any work during that recovery period, all of a sudden they're going to tack on that penalty. It's the same penalty that they tack on for a missed meal and rest period. Okay? An additional hour of pay at their regular rate of pay. All right? The problem with this is because those recovery periods are needed can be taken on an as-needed basis, it's going to be pretty hard for the employer to come back and argue, well, yes, we provided them. You're trying to prove a negative. I think given the sort of ambiguity into how this is going to play out, this may well be the new arena that we see of big class litigation. We had lots and lots of lawsuits over that meal and rest period penalty, okay? And now we've got a whole new avenue for them to get that. Yeah, Joanna?
For example, we work outdoors, and we provide typically at least 4 breaks. We're only legally required 2 for 8-hour shifts, but we don't clock it. Do you recommend we begin to clock, keep note of breaks, or is that more risky to do so?
No, I think, and this is a good question. And for people that are streaming, the question was, do you recommend having people clock or mark down to note that they're taking a break? Typically, we don't have people do that because that rest period time is paid, okay? The problem with the recovery period is even though they're only entitled to 1 break every 4 hours or a major fraction thereof, if I just took a break but it's 106 and in 20 minutes I get hot again, I might need another break. And the key, I think, for the employer is you need to make sure you adequately train your supervisors so that they understand when someone says, hey, I need a cool down period, I need, that the supervisor is tracking that, yes, these were provided. I don't think you need to have that employee clocking in and out or making those notations. You might also want to consider having something on the time card that says, I understand that I'm entitled to take the recovery period on an as-needed basis or something along those lines. The key is you want to communicate that information to the employee, okay, so that when they come back and say, hey, I didn't get any of my recovery periods when I needed them, you can say, well, you knew that you were allowed to have them, we explained that to you, and you never asked for them, okay, because that's where we're going to see the discussion. And the employee is going to say, I did ask for them, and the supervisor winked at me and glared at me and said I couldn't take it, and that's how, yeah. It's as needed, yeah. So just watch, yeah, the employee who's like, I'm hot all day long, so I just need to sit here all day, Yeah, it's as needed. So.
Can you discipline them for taking too many?
No, yeah. You don't get to retaliate against people for taking those rest breaks. If you've got an employee, though, who becomes so overheated, after they walk out into the sun for 2 minutes and they're overheated, at some point, they're not going to be able to perform that the essential job duty of working outside. It may be a disability, it may be some predisposition they have to heat or something along those lines. So there might be ways you can get around that. But I certainly don't want you to, come down on your employees because they're taking those recovery periods, And truthfully, you don't want your employees to overheat and, die because it's really, really expensive, okay? It's a lot more expensive than the cost of the recovery period, that's for sure, okay? Plus, it's really sad and horrible. Okay, this next one, AB 263. This is basically just an expansion to the penalties that you can get if somebody complains about a labor code violation. I didn't get overtime, or I didn't get my final pay, or whatever the case may be. If they complain about that, and if you take adverse action against them or retaliate against them, all of a sudden these penalties can be triggered. Before this law, you weren't allowed to terminate them and you weren't allowed to discriminate against them. Now we've added adverse action and we've added retaliation as protections. But the other thing that this law did was the same thing that independent contractor law did a couple years ago. It ratcheted up those penalties where they used to be $100 a violation and then $200 for each violation thereafter. It's now $10,000 for a violation and upwards to $25,000. Okay, so big penalties. All right, you don't want to take adverse action against somebody when they complain about the wages. Is the bottom line. Okay, you didn't want to do it before, but you really don't want to do it now. All right, I'm going to move to page 4. Sorry, my stuff's falling apart. SB 462, attorney's fees where the employer wins. Okay, they could have titled this law "No Attorney's Fees for Employers." What they basically said, if you are the employer, okay, and you're trying to recover your attorney's fees based on a case that was, frivolous or whatever, you need to make what's called a bad faith showing. They didn't define exactly what bad faith is, but in other situations, it's malice. It's something intentionally wrong. I'm just making this case up out of whole cloth just to sock it to the employer. Okay, it's a very, very high showing, very difficult for the employer to reach that showing. Basically, what they're saying is, you employer, when you win, are not going to get your attorney's fees. Okay, and this law was in response to a California Supreme Court case that left that question open. What you'll see with a lot of these laws is I'll come and do the update and yay, we have this great employer victory, here's this good decision, okay, and then here comes California legislature in and they just start drafting and working as fast as they can to undo that court decision, okay, and this is an example of that. We had Kirby v. Imus Fire Protection, and that case had left open, hey, an employer may be able to get their attorney's fees, and they came back and said, nope, you don't get to do that unless you make this heightened showing of bad faith. AB 556, which is the next one, they have added military and veteran status as a separate protected classification under the Fair Employment and Housing Act. Okay, they did something that's kind of interesting here because they said, you don't get to consider military and veteran status when you make employment decisions unless you're going to consider it to give preferential treatment to veterans or people in the military. Okay, so you can consider it if it's for a positive purpose, but not a negative purpose. Be very careful if you're thinking of doing that, only because the EEOC has already sort of opined that, treating people differently based on military status may disparately impact women, since there are fewer women in the military than men. Okay, so you want to be very careful. That disparate impact, and what I mean by that is a policy that more heavily impacts one protected group than another. Okay, it's good. There's sort of the systemic discrimination idea, and that's really been a big push on both the federal side and the state side in terms of the enforcement stuff. When they come after employers, you're discriminating because this policy weeds out, this racial group or this gender or this age or whatever you have it. Okay, so be very careful. I don't like giving preferential treatment to anybody because I think, no good deed goes unpunished. It's going to come back to bite you in the end. The next one is SB 292, sexual harassment definition expanded. This is another one where we had a great, court case, and then here comes legislature in to fix things. Basically, that case had said the plaintiff didn't get to proceed on their sexual harassment claim because there was no sexual intent, sexual motivation, or sexual desire that was associated with the comments. Okay, and this law says no, you can have harassment even if there's no sexual motivation behind what's being said, okay? Basically what this says is those jokes, the hazing, all that teasing and stuff can certainly provide a basis for a claim, okay? You can have a hostile work environment even if there is no actual sexual desire on the side of the person who's harassing, okay? It just makes it all the more important to do that harassment training, really. And you only need to, if you've got 50 or more employees, you only need to train your supervisors every 2 years, but I would certainly encourage you to train all of your employees. Your employees can stir up just as much trouble as supervisors 9 times out of 10, so it's certainly a good idea. SB 496, expanded whistleblower protections. This law really did 3 things. They added retaliation in. You can't retaliate against somebody who blows the whistle on something. They also added in, if they're blowing the whistle and it's just like a local rule or an ordinance that they're blowing the whistle on, okay, that's also going to trigger those protections. Before it had to be statutory and a law that they were complaining about. But the real kicker is they basically said, disclosures or complaints that are made to a person with authority over the employee or another employee who has the authority to investigate, discover, or correct the violation are going to trigger those protections. What that means is all of a sudden internal complaints by the employee are going to trigger those whistleblower protections. Before they had to go to a person of authority, the agency, and complain. They're going to OSHA or somebody. Now they can just make that complaint internally and trigger that. So you need to be really, really careful. This is train your supervisors, okay? Because that's who that complaint is going to come into. All right, make sure they know how to handle it, make sure they know to route it up the food chain, make sure they know how to handle this employee, make sure that this isn't something that gets brushed under the rug, okay? Because down the road, when you want to fire that guy, all right, you may have some trouble doing so, or you may end up shelling out a lot of money because you did, all right? So this is a big one, and this is another one that really hasn't gotten a lot of press, but has the potential to really sort of create some big problems for employers. On the next page, I'm on page 5, that third bullet point down, SB 288 and 400. This was sort of an expansion of those time off protections for victims of crimes, and they added stalking as another category where you need to provide employees with time off so that they can, go to court and get a protective order or whatever they're going to do. One of the things I want to highlight with this, though, is when you think of a crime victim, okay, your employee doesn't actually need to be the victim. Okay, the victim includes somebody who is the grandparent. Let me see, it's grandparent, parent, spouse, child, guardian, sibling. Okay, they're also going to be covered under those victim protections. All right, so watch for that. And then the stalking piece, we're getting ready to do not this month, next month, I think, or 2 months from now, a lunch and learn that's all about reasonable accommodation. Okay, they added that accommodation requirement for stalking victims. So when your employee comes in and says, oh dear, I have a stalker, okay, all of a sudden that triggers for the employer that interactive dialogue process of, okay, what can we do to work with you to make the work environment safe for you, safe for your coworkers, you may need to change locks, change their phone number, whatever. It depends on the circumstances, what's actually reasonable, what's going to work and help them. But that's now a separate obligation to engage them in that dialogue of what they need to have done, okay? Because you didn't have anything else to do. So now you have one more thing to put on that to-do list. So that's one to watch for. On the next page 6, I want to talk about that IRS ruling. Automatic gratuities are going to be considered service charges. Okay, I've got a lot of clients that are in the hospitality industry, and basically what an automatic gratuity is, you go to a restaurant and you've got, I don't know, more than 10 people or something, and so they tack on that, 15% or 18% tip automatically, okay, and it just comes as part of the bill. The IRS has said, well, we're going to consider that to be a service charge. When something is a service charge, it's no longer discretionary, okay, so that payment comes in. This is not a discretionary payment to the server, to the employee, okay, it is a non-discretionary payment. Non-discretionary compensation needs to be included when you calculate that regular rate for overtime, okay, so you may end up owing additional money to those servers if they're working overtime. Okay, it's something you're going to need to take a look at. The extra compensation that, shucks, we didn't figure it into the regular rate of pay, okay, has become a very popular claim. Okay, because if you're figuring it out wrong for one of your employees, you're figuring it out wrong for everybody. So it's ripe for a class action lawsuit, which of course carries a lot bigger judgment, settlement, payment, and so forth. Okay, so this is an area you really, really want to look at. If you are in the hospitality industry, I would suggest that you, instead of having an automatic gratuity, you have a suggested amount or something. Don't make it so that it just gets tacked on right away. Okay. You also can't use those service charges as a way to offset minimum wage obligations. There are some other things to consider. So I just highlight that for our hospitality clients. The next page, there were a handful of new things, new laws that impact prevailing wage obligations. Okay, so if you've got a public works kind of contract, you might want to take a look at that. I'm not going to go through all of those. Some new laws for workers' comp, just some other things to be aware of. And then, of course, we had affordable care. The days of hoping that affordable care will go away, I think, are gone. It's coming. So you just need to get ready for it. There isn't a whole lot to do at this point from the employer standpoint. We had, as of October 1, we had to get that availability of coverage notice out, and hopefully everyone got that out. If you didn't, I can get you the forms. They're available online. And then Covered California went into effect in October. Isn't a lot to do right now. And as we get closer to January of next year, I'm sure we'll do more updates on this kind of stuff. But just know that it's coming. The key really is planning from a fiscal place in terms of how you're going to absorb those costs, because there obviously are going to be costs associated with putting that in place. I'll end on a high note on page 8. Remember that NLRB poster we had, and we went back and forth, and they had until January 2nd to appeal that to the Supreme Court, and they opted not to appeal it. So the obligation to do that big NLRA poster is gone, and hopefully will stay gone. So that's really it from a legislative standpoint. Are there questions about any of those laws? I want to make sure we have enough time to march through these cases. Everybody good? Okay. All right, so I'm going to start with the hiring stuff. This is hiring and independent contractor issues. The first one, check passed. Okay, this is your reminder of why you use a third party to do the background checks. Okay, they use CheckPass. CheckPass gives them the information. Oh, whoops, it has like bankruptcies going back, 15 years and, all sorts of other stuff that's not supposed to be on there. When the lawsuit comes in, it comes in against CheckPass. It was not filed against the employer. Okay, anytime you can, dodge liability and put it on some other company, that is my best legal advice, do it. Okay, so just a real reminder. The other piece that I take from this case is don't assume just because you farm something out to another company that it's being done correctly. Okay, I've spent a lot of last year going through wage statements from reputable national companies where stuff is not being reported properly. So make sure you go back, and of course we do payroll services that I know are correct here, but make sure you go back and look at that stuff, okay? Because it's a lot cheaper to fix on the front end than in a deposition. All right, the next one that I want to talk about is this third bullet down, California Science Center. This was a public employee who filled out an application and lied on that job application. Okay, we've had this same type of case in a private arena. It's the first time we had a public employee that was going through this. And basically, he worked for the sheriff, I think, yeah. He worked for the LA County Sheriff, and he had a personal relationship with someone who was under investigation. Okay, whoops, that's not a good idea. And so he gets fired. He applied for a security officer job or, whatever, security guard job, and he put on there that he'd been fired because he didn't report a relationship with an informant, not somebody under investigation, blah, blah. Okay, so 2 years later, they discover that he's lied on his application, and they fired him for it. Okay, and he, of course, sues for wrongful termination. This isn't fair. And the court said, nope, that's a valid basis. If you're lying on that job application, and, you maybe shouldn't have been hired in the first place. The takeaway lesson, okay, have job applications. Have job applications that ask for this kind of information. Why were you terminated? All right, you lock them into a position that you can maybe use down the road. Okay? If you got somebody who's willing to lie on a job application, probably they're going to come into your workplace and lie about other stuff. Okay? So it is really a useful tool to have in your back pocket. The next one I'm not going to talk about. I talked about that the last legal update I did over the summer. This is the unpaid interns. I just want to highlight the fact that if you're using unpaid interns, make sure they are actually interns. Okay? They sort of relaxed the requirements for interns. The labor commissioner said, well, we're going to go with the federal rules. And of course, the federal rules, as opposed to state rules, are generally far more generous to employers. And so they said, well, when it comes to interns, we'll just look at federal law, and that will decide who's an intern and who's not. And so all of my clients said, yay, we're firing our employees, we're hiring a bunch of interns. Okay, not a great idea. Okay, the key with an intern, when it comes down to it, is there needs to be some benefit to this intern. Okay. If they're more of a hassle to you, employer, then they're probably an intern. Okay? If you're getting a benefit from them and they're doing all sorts of great stuff for you and you're saving much money, they're an employee. Okay? That's your sort of shortcut answer. But be careful, because there are certain areas that just attract a lot of attention from the plaintiff's bar, and those suits get filed. And interns tends to be a hot topic at the moment. On the next page, Hunter v. CBS Broadcasting is a pretty interesting one. And this is a California Court of Appeal. He applied for a job as a weather person, and they said, sorry, we're hiring cute young females to be weather people, because when we have a cute young female weather person, our viewing goes up and our blah, blah, blah. Okay, typically that's not the policy I would advise you to have, okay? But anyway, so he files his suit. I'm old and male and ugly or whatever, and says that's not fair that they didn't hire me. And the court dismissed the claim. They said CBS, when they cast for that weather person, it's just like casting for a TV show or something. They put it in that entertainment world and said this is their First Amendment right to free speech. They can broadcast this speech however they want. So it was a surprising decision. I suspect it will get appealed. And we'll have to see where that shakes out. But yeah, so the takeaway is if you're old and male and ugly, you don't waste your time applying to be a weather person, I guess. Okay, so that pretty much does it. The in the news sections, and in each one of these headings, I try to just pick out things that I think you might want to be aware of. The two big takeaways from this is really that push on systemic discrimination. That's what they're really looking at. So if you're doing things like criminal background checks or credit checks, things like that as part of your hiring process, make sure that it is really linked to that job, that there's a business necessity reason for doing so. There isn't a lot of guidance on what that is, but certainly you want to have your ducks in a row before you start doing that kind of stuff, because pretty much from the Department of Labor all the way down, the chain, they have all said, if you're using criminal background checks, you're going to weed out certain, minorities, certain ethnic groups. If you're doing veteran checks, you're going to weed out women. If you're doing credit checks, you're going to weed out certain, they really have targeted that kind of stuff. And again, those cases tend to be pretty costly because you're going up against the full weight of the government. So, questions on hiring? Nope? Okay. Let's move to wage and hour. The first one, if you didn't believe me that there's, no good deed goes unpunished, how about Anheuser-Busch, where they give out free beer to the workers, okay, and then the workers come back and say, this was compensation, And they didn't account for that when they figured out our regular rate of pay. So when they figured out my overtime, they weren't factoring in the $4 versus worth of beer that I got over the course of the week. Okay, and that's where they end up with this case. Yeah, really. I mean, okay, make sure if you are giving other perks to your employees, okay, if those are non-discretionary, you know, you get a Target card if you bring somebody on board, you get a whatever. Make sure you consider that stuff when you calculate that regular rate of pay. Okay, this is again another area that's pretty popular in terms of new litigation. And you know, probably also not a good idea to give out free beer to your workers, just from a totally separate you know, angle. Falconberry v. Boyd, I talked about last time, but really this is sort of the roadmap to meal and rest claims going forward. What the court said is if you have a uniform policy, okay, that applies to everybody, and that policy is against the law and illegal and says things that are not, you know, right, then you can get hit basically with a class action. Okay, you're gonna, in that case, they had, you know, I think the meal and rest policy was something like you don't get to take your meal period until somebody comes to relieve you. Well, that's not really what the meal period rights are in California. Okay, you get to take it before the end of the 5th hour. It has to be 30 minutes, uninterrupted, duty-free, blah, blah, blah. Okay, so make sure it's always the beginning of the year a good time to go back through that handbook, take a look at those policies, update whatever needs to be updated. Okay, just make sure, because if you've got policies in there that are not good, all right, you're a sitting duck for a class action lawsuit. All right, the hope when Brinker came out was that, oh good, we're not going to have any more class actions with meal and rest periods, but of course that is not the case. The next one that I want to talk about is one that I talked about last time also, Gonzalez v. Downtown LA Motors, but this is really worth another look, particularly because they appealed it to the California Supreme Court, and the Supreme Court said, we're not going to review this. So this is good law in California, and it's probably going to stay this way for a while. What they did there, this was a mechanics place, and a lot of times mechanics are paid on what's called a flag rate. It's basically a piece rate way of paying somebody. You know, if you do X number of, you know, widgets, we're going to give you this much money per widget that you do. Okay, in the case of mechanics, they'd say, well, we're going to give you 4 hours of pay for each brake job you do. Okay, it might take you 2 hours to do it, or it might take you 4 hours, but you're going to get this set flat amount for each brake job. Okay, sounds good, and that's how historically it's been done for years and years and years. Well, these people sued because they said, well, great, when I'm doing my brake job, I'm getting paid, but when I'm sitting there for 30 minutes because there's no cars that are coming in to have their brakes repaired or their, you know, lube job done or what, I don't know anything about cars, whatever they come in to have done. When they're sitting there idle because there are no pieces for them to work on for their piece rate, okay, they said they weren't getting compensated. And the employer said, well, yeah, but you know, they worked 8 hours, and over the course of that 8 hours, they made more than minimum wage per hour when you look at their total compensation for that day. And that had been fine for many, many years. And the court said, no, that is not okay. They are entitled to separate payment for all the time that they spend waiting to work on pieces. Okay, so if you're paying people on a piece rate, make sure that they're working the whole time, okay, or make sure you're paying them at least minimum wage for all of that downtime. Okay, and there are some different ways you can absorb those costs. You may, you know, reduce the per piece rate. You might just pay them across the board minimum wage, or you know, some lower hourly wage, and then give them a production bonus or some other things you can do. But just be mindful of that, okay? Because for each minute that they're at work, they're entitled to pay, whether they're working on a piece or not. The next one is Green v. Bank of America. These are our seating cases. You probably heard about this stuff. This was the big, you know, after 99 cent only, I think, got hit with one. And they're just starting to finally trickle into the courts. We had, Bank of America had initially won this case, and they won on the grounds that the person never asked for a seat. Okay, so now they're suing, you didn't provide me with a seat. They said, well, you never asked for one. And the trial court said, yeah, you never asked for one, you don't get a seat. Okay, it goes up on appeal, and on appeal, the court said, well, you know, if you look at the wage order, it just says employer shall provide. It doesn't say employee shall ask. Okay, so this case got sent all the way back down, so we'll see how this shakes out. The other seating case that made its way to court was against Kmart, And they basically said, Kmart wins, you did not need to provide seats, because Kmart was able to show that if, in order to fit a chair into that checkout stand, they were gonna have to, remodel every single Kmart across the country. And they said, well, that's obviously not reasonable. But remember, in that decision, they also said, well, a stool might have fit in there, so you could have this little leaning stool or something. So, we'll have the stool cases next, I guess. But the point is, if you've got, whether they're tellers, they're checkers, they're, whatever, sitting at the hostess, I don't care who they are. If they're in an area where it's possible to fit a, $10 stool from IKEA in there, put a seat in there. Far, far cheaper, okay, than having to deal with this kind of stuff. And those are all just proceeding along. So we'll see. And actually last week, I think, the courts just asked the California Supreme Court to weigh in and provide a little more guidance with respect to what that provide suitable seating requirement actually means. So hopefully we'll get a little bit of a break on that one. On the next page, there's some of these pending cases I want to just highlight for you. The first one is that Mendiola v. CPS Security. These were 24-hour security guards, and they had a really horrible schedule because they worked 24 hours a day, all week and all weekend. So not a great job. But they sued, and they sued because they wanted to pay for their on-call time. And the court did this really sort of crazy analysis where they basically came to the conclusion that their on-call time during the week was not compensable, okay? But their on-call time during the week was compensable, but their on-call sleep time during the weekend was not compensable. And I mean, they were basically doing the same thing. It was a really crazy decision, and the California Supreme Court, I think, thought it was kind of crazy too because they granted review. So we'll see where that one shakes out. It's an important case to watch, though, if you're in that personal attendant world, okay? Because if you're gonna try and have somebody that's there 16 hours and deduct 8 hours for their sleep time, you're gonna wanna see what the court says about that. Okay. Also for employers who have people that are on call, you're giving them a cell phone and you better call in if the, factory is burning down or whatever. At what point do you really need to pay them for that time? Okay. And typically it's how limited are they and what they can do during that free time. Can they go wherever they want? Can they drink alcohol? Do they have to call you back within 2 minutes? Do they have to show up? How much restriction you put on them is going to dictate whether you need to pay for that time. But hopefully we'll get a little more guidance from the Supreme Court from that one. The other one is this Sandifer. That's a donning and doffing case. Okay, when I say donning and doffing, what I mean is when you have employees that need to do pre or post shift activities, at what point does that trigger that obligation to pay? If they have to come in and put on a whole hazmat safety gear thing, well, they're probably starting work at the minute when they start putting that stuff on, not at the minute when they get into the workroom where they actually start performing their duties. Okay, so watch for that. If you've got people who are checking out tools, checking out equipment, putting on safety gear, those are all things you're going to want to watch for. And actually that kind of dovetails with that first bullet point under in the news. Apple, and there's a whole bunch of other stores, but the first one that got hit was Apple, and they had these bag check policies. Okay, as you're leaving the store, you got to open your bag and they look to make sure you didn't steal 5 mini iPads or something. Okay, takes 1 to 2 minutes. Well, if there are 4 employees that are getting off at the same time and the supervisor has to look in their bag and they have to look in their bag, maybe it's 5 minutes of time, okay? And they said, look, that time's not being compensated because I already clocked out and now I got to stand here in line with my 5 other employees and have my bag checked. Okay, so just watch for that. If you've got security policies like that, pay them at the minute they walk off of the premises, okay? Because that's a little bit scary. And if you think back to that LoJack decision 3 or 4 years ago, that was the guy who, would plug in his computer at the end of the day and, send information to the LoJack mothership. He sometimes would get booted off and had to log back on. Okay, and they said, well, it might have taken him 5 minutes a day to send this data and to log on and re-log on. And at 5 minutes a day, they found that that was compensable time because 5 minutes every day is 25 minutes a week. That's almost a half hour. Okay, so be careful. I have a lot of employers that say, oh, this should be that de minimis exception. Okay, the de minimis idea is that if this is work time that's so small that you can't capture it as a practical matter in the payroll system, you don't need to pay for it. What they mean by de minimis is, you know, a second, a minute. It's probably not anything. It's when you're walking to the parking lot and they say, hey, did that fax go through? Yeah, it did. Okay, you don't need to run back in and clock in, point for a second because I answered the question about the fax. Okay, that's de minimis time. It's not, okay, I'm standing here waiting to get my bag checked for 5 minutes. Okay, so be careful with that one. Nordstrom's gotten hit. There was another one I just saw that came through this morning. So those bag checks, popular these days. Okay, so that's the wage and hours section. Questions? You guys are all full and sleepy. Everyone's like, yeah, I'd like to sedate you before I give you all this horrible news. It's a good plan. Moving to leave of absence, I'm on page 15. This first bullet point that I want to talk about is Lexmark International. They had a use it or lose it vacation policy. Okay, use it or lose it policies are not legal in California. And what I mean by use it or lose it is you've got vacation days, okay, or you've got PTO that you've accrued, it's on the books. Oh, we hit December 31st, we're not going to let you carry that vacation over, so you lost it. You didn't use it, it's gone. Okay, that doesn't work in California, all right, and that's because they view vacation and PTO as deferred wages. So whatever they've got on the books, those are wages. You don't get to take the wages back from the employee, okay, just because you've moved into a new year, all right, so that's stuff you don't get to take. That's not the same for holiday pay or sick pay, okay? If they don't use their sick days, you don't have to roll those over. You know, guess what though? If you give somebody 10 sick days, they're not going to have any sick days left come December 31st. But that's that anyway. So for vacation, for PTO, we don't get to take those away at the end of the year. I highlight this one because for employers that have multi-state operations, and that's what happened here. This was a California business. Okay, they had this great vacation policy. You got to roll everything over. They get bought out by a company that's not in California. And when they're bought out, hey, we're going to streamline everything. We're going to bring you in line with all of our other offices and super, okay? And then they rewrite all the policies so they're illegal in California, okay? I've got a lot of clients that say we want to have a uniform, you know, handbook for our Texas office and our North Carolina office and our California office, okay? Well, then you better extend those California protections to everybody, or you better have a California-specific handbook, okay? Because the laws in California very, very different than the laws in most of the rest of the states. Okay, so just be careful of that. Proc v. Tim, oh yeah.
Is it okay to cap it? You know, if they get to a certain accrual rate, can you tell them it stops?
Yeah, so the question for people streaming, the question is, can you have an accrual cap? Yeah, and the key, and that's sort of the end around in terms of the use it or lose it. And the accrual cap basically says you're not taking accrued vacation away from them, you're restricting their ability to actually accrue it. Okay, so you can accrue up to X point, and once you hit this point, you are no longer accruing that vacation. Okay, you need to give them a reasonable time to use that vacation that's there, so that they can, you know, not necessarily hit the cap. But yeah, question.
Has there been litigation where they are at a max and they are denied being able to take vacation during X amount of time, so then they stop accruing? And yeah, you see where I'm going?
Yeah, I see where you're going. Yeah. There's a plaintiff's lawyer in the room. No. You know what? I don't think there has been a case about that, but I'm sure there will be. You know, it's a really good question. I think it's really going to turn, I think, when you've got somebody who's asking for a vacation and you're denying it, it's going to be a factual analysis. Well, what are you denying this based on? Is this, it's tax season and, oh, hi, it's April, 12th and I'd like to take a vacation? You know, that is one situation. If this is something where other people in the company are taking vacations, but this person can't, it's not your busy season, I think that's what that's going to turn on. You know, but it's a great question. Yeah.
So this vacation policy is probably a good, I mean, that's not only for salary employees, that can be hourly as well, right?
Yeah.
You have a policy on both.
The policy on both, yeah. Well, and I have a lot of employers that their vacation policy really only applies to the hourly employees, okay? Because the salary people are going to get their salary regardless. But if you have a company-wide policy, yeah, that's what we care about typically, yeah. Okay, are there other questions? Don't be shy. Okay, Proc v. Tamura, that's at the bottom of page 15, and carries over to the next side. This one, I talked about last time. I'm not going to spend a lot of time on this, but it's just a reminder, okay, that interactive dialogue process is an ongoing process. Okay, this person requested leave, okay, they did the interactive dialogue, he came back and requested additional leave, and they said, oh, I'm sorry, your leave's up, so you're supposed to come back, you're fired. Okay. They tried to defend that case based on the fact that there was no accommodation they could have provided at that time because he was totally disabled. There was nothing he could do. He's bedridden. There's no way for him to come back. So what's the point of doing that interactive dialogue process? And the court said, the point is you have to do the interactive dialogue process. Okay? So in that conversation of employees saying, I need leave or I need an accommodation, and you say, well, what would you like to do? And they say, how about we do this? And you say, that's not reasonable. You go back and forth and back and forth. This is an ongoing duty. You don't do it once and then you're done. Okay? Each time they come back and say, I'm still not able to come back, you have that obligation. That doesn't mean you have to keep them employed forever. It just means you need to go through that conversation with them. A good way to think about this is if you've got conversation coming, employee says this, you say that, I want the last piece of correspondence to be from the employer. Okay, this is why this isn't reasonable. Please, give us some other alternatives. Your leave has been extended for 8 months and it doesn't look like that's helping you at all. Let's come up with something else. We need a doctor's note by X date. Whatever the case is, I want that final piece of correspondence to be from the employer. Okay? Where you get into trouble is when the employee says, well, I asked for leave, I told them I couldn't do this, and then they just said I was fired. And the employer says, well, she was supposed to show up on January 1 and she didn't. Well, if you aren't communicating that with the employee, okay, if you can't show your good faith in doing that conversation process, all right, that's where you're going to get hit. And it didn't matter in this case that the person couldn't come to work anyway. There was no accommodation that was available, okay? But the fact that the employer didn't ask that question is what got him in trouble. Okay, so it's a big reminder. In the news, we had a bunch of sort of new changes, or not changes, but sort of updates in terms of guidance and regulations, particularly with the Family and Medical Leave Act. The first one being we had same-sex marriage. That Defense of Marriage Act was struck down, which means that same-sex spouses are now going to be entitled to FMLA coverage. Okay, it's not such a big deal for us in California because we already had domestic partners that were covered, but just be aware of that. The sort of interesting thing from the FMLA purpose is you need to be married in a jurisdiction where they recognize same-sex marriage, okay? And then you need to work and live in a jurisdiction where they recognize same-sex marriage in order for those FMLA rights to apply. For the IRS stuff, in terms of your federal taxes, it's a little different. As long as you get married in a jurisdiction that recognizes same-sex marriage, it doesn't matter where you work or live, those protections are going to apply for tax purposes. So, and we're just starting to see how all this is going to shake out. You've got everybody's a lot of cooks in the kitchen, so I imagine there's going to be a lot of sort of confusing stuff. At any rate, same-sex spouses get FMLA protection. Okay, the other change we had was, or not a change, but just sort of more clarification. Adult children, what are the leave rights if you are a person trying to take off time to care for a seriously ill adult child? Okay, so if your employees have that, there's new guidance on that. And then they expanded some of the military and service member protections. Pre-existing conditions, I think they added veterans in and some other stuff. Okay, so that was the leave of absence piece. Okay, on time. Privacy, technology. All right, the first one, Alma Products. When you talk about giving bad news at the illegal update, this is where it's all packed in. Okay, so they had a policy that says you can't have derogatory language on your clothing when you come to work. And the person came to work with a shirt that said slave, and then it had a ball and chain on it, okay? And they said that's not appropriate. I think they sent him home without pay. And so, of course, he files claim. Instead of going home, he went to the NLRB office. Anyway, he files his claim and says, this policy violates my rights under the NLRA, specifically Section 7, that says I can engage in concerted activity to further better working conditions. Okay, and the NLRB said, yes, that does inhibit speech. It might inhibit discussions among employees. Those employees might be going to talk about how to organize. So you don't get to have a policy that says no derogatory speech on your clothing, okay? It doesn't say that you can't have a policy that says we require professional attire, okay? I would certainly encourage you to have something along those lines. I typically advise my clients, I don't want any kind of fashion extremes, okay? Because I've had a lot of clients that it's a professional office, well, somebody shows up with a blue mohawk one day. Now what are you going to do, okay? You can't really, get mad at the employee for, appearance issues, but if we're trying to keep everybody in line with the image we want to project to the public, probably safe bet is just to say we're not going to allow any fashion extremes, and we require some sort of professional attire. Then, of course, you need to enforce that and be consistent, okay? You don't get to just pick out the, whatever, lesbian, Muslim, transgender, whoever, and apply it only to them, okay? We got to go with everybody, all right? There's another case, actually, well, we'll get to it in a second, that's sort of along those same lines as that dress code policy. Bland v. Roberts, I just want to highlight because I told you in July or August that a Facebook like was not protected free speech. Went up to the Virginia Appellate Court and they said, yes, a Facebook like is free speech. Okay, this was kind of a funny case because it was a sheriff's office and he was apparently a big jerk. And so all the people in the sheriff's office liked the other candidate who was running against him. So, he got mad and anyway, big lawsuit now. At the lower court level, they said clicking a button, and simply clicking a button is not enough to trigger those free speech rights or protections. And the appellate court came back and said, yes, this, evidence is a message, so it's going to be protected. Boeing is a big one. I spent last November and December, I think I probably did, 10 to 15 harassment investigations. Okay, it's just, they were all over the place. Here they said the employer's policy that directed employees to keep that investigation confidential violated the NLRA because now you're curtailing workplace discussions and concerted activity and speech. Okay, so they changed the policy and said, well, you're not directed to keep it confidential, but it's recommended, I think was the word. It's recommended that you keep this confidential. And they said that also violates the NLRA because they might be persuaded that they shouldn't talk about this stuff. Okay, so take a look at that. I know in all the investigations I do, I always say, let's not try and discuss this with everybody. Okay, probably not something you're allowed to do anymore. It's not a great case, okay, obviously, but the practical effect, I think, truly is going to be pretty minimal because if you thought you were keeping any of that stuff confidential, guess what? It spreads like wildfire. So there isn't probably going to be a huge impact, but just make sure if you've got documents in your harassment investigation procedure, take out that confidentiality piece, or don't have it in writing at least. Butler Medical Transport is really kind of an interesting case because it's sort of two different sides of maybe the same issue. The first one, a girl gets fired, okay? So her friend at work says, hey, why'd they fire you? And she says, oh, they fired me because I complained about our work cars. Our work cars suck, they're horrible, and I complained about it, and so they fired me. So the friend goes on to the girl who's been fired's Facebook page and posts, hey, you should talk to the labor commissioner or get a lawyer because this might not be okay that they fired you, okay? She comes to work the next day and they say, hey, you're trying to drum up a lawsuit against us, you're fired. And they fire the girl who's posted on the friend's website, go to the labor commissioner, okay? And she sues and they say, well, the comment to go to the labor commissioner is really a comment to try to get the employer in trouble for these bad cars, and getting the bad cars problem resolved is trying to improve working conditions. So even though it was a single comment and no one's responding back, it's concerted activity because it's based on her telling her it was for the cars that she was fired. I mean, they just go around and around and around. Eventually they get to the place that you don't get to fire this girl for encouraging her friend to file a lawsuit, okay? Same employer, okay? Somebody else has posted on their Facebook page, what's the statement he said? Hey, I'm effing broke down in the same S I was broke in last week because they don't want to buy new S. Okay, so that's what he posts on his Facebook page, and they say, thank you very much, here's your paycheck, and they fire him. Okay, and he files a lawsuit and says, well, I'm complaining about the workplace cars because I'm trying to get better cars here. okay? And they came back and said it was okay to fire this guy. The key, it's not because he was swearing, okay? It's not because nobody else was commenting. The key with this guy was the fact that they could show at the time that that post was logged, he was not in a work car, so he was not broken down, so it was false, it's malicious, and that's how they got around it. Okay, but don't assume just because somebody's, dropping the F-bomb or whatever online that that's going to be enough to fire them. Okay, if what they're talking about online relates to people at work, relates to conditions at work, relates to wages, any of that kind of stuff, be very, very careful in how you handle that. Okay, it doesn't mean you can't discipline them, it doesn't mean you can't talk to them about it, but just be very, very careful. Okay. The next one, this Ealing non-public Facebook posts. This person had, and this is a question I get a lot, if an employee has a Facebook page, but it's double secret, padlock protected, triple word, whatever, double secret probation protected, nobody can get into it, can I use information that comes to me from that Facebook page? Okay, and what the court here said, she was an EMT, I think, yeah, and her coworkers arrive at this place, a scene of a shooting, okay, and she posts, I wish they would have let the shooter die, okay. A coworker sees this, takes a screenshot picture and shows it to the employer. She is saying that the patient should die. Okay, that's not good. And they put her, I think, on a unpaid leave or sent her away, or disciplined her. And so she files this claim, and she says, look, this is on my super secret, double, triple protected Facebook page. The employer doesn't get to use that. That's private information. This is my private information. And the court said, look, if it's totally password protected and double sealed and all that, it's going to be covered by that Stored Communications Act, which basically says this is private information you don't get to use unless you're an authorized user. But what they also said, okay, is that it might fall under this exception, where an authorized user can get to it. If that authorized user takes it and shows it to somebody else, you don't get to claim those Stored Communication Act protections. So what you had here was, because the employer they didn't ask for the information, go check out her Facebook page and see what she's posting. Because they didn't direct it, they didn't solicit it, it just came to them, it was okay that they used it. Okay, so her discipline was justified based on the information they had. So when you're sitting in your HR office and some employee comes in and says, guess what Susie's putting online, that doesn't mean that you can't act on it. I think there's also a pretty strong argument that even if something is, triple protected and password and blah, 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 if you have 2,000 friends, how private is it really? Okay, so I think there are some ways to get around. Plus, if you have employees that are logging on a work phone or a work computer or using the work server or the work Wi-Fi system, that there's that nice little box, check here if you don't want to have to, input your password ever again. As soon as they check that box, they just gave you their password. So is it really, private? So go change your passwords and then don't ever check that box again when you're at work. But those are, I think, some of the considerations in terms of how this stuff is going. On the next page 20, that world color, that's the one I said was kind of like the dress code policy. This is baseball caps. They said you can only wear baseball caps at work if they have the company's, insignia on it. And the NLRB said, nope, that's not okay. You don't get to prohibit that, because what if somebody wanted to wear a baseball cap that had a union insignia and then they couldn't do it, and that's not fair. So, yeah.
Our company hats are, we only permit crews through specific company advised
Yeah.
hats. Is that a violation?
Well, it might be if you get, it's only going to be a problem if somebody goes and complains about it, I think, yeah, that's basically what that NLRB judge said there. These, when I say an NLRB judge decided it, these are at an administrative level. So is that something that's going to govern in California? No, not yet, okay? But when we get that case in California, that's where they're going to look for guidance. So, it's probably not a good idea. What you can do as an alternative, allow whatever baseball caps you want, but hey, if you're going to wear a cruise-through baseball cap, you get an extra, whatever. You get a free car wash at the end of the week, okay? Then take the value of that free car wash and figure it in when you calculate their regular rate of pay. Yeah. So, yeah. Okay, in the news, I just highlight that increase in usage. This is Pew Research Center, but they're showing adult usage 72% in 2013 of adults are active on social media and online. I cannot tell you how important it is to have a social media policy at work. Okay, it's coming into your workplace with your customers, your workers, everybody. So be very, very careful with that stuff. And then we had an advice memo that came out about camera phones, okay? And they basically said, nope, you can't prohibit employees from taking pictures at work. I think if you're in the medical field, there are some other considerations that might trump those rights of the employees, okay? We've got HIPAA things and other things to be concerned about, privacy rights, patient rights, and so forth. So I think if you can find something akin to that to justify that ban on phones, then you're going to maybe be okay. But for everybody else, it's just a regular office. I don't think I can, maybe if you're in a bank and you've got access to, confidential, personal information, things like that, social security numbers and stuff. But just be very careful. And Subway really saw the downside of this because they had a guy who was posting pictures, foot-long pictures with his foot-long sandwich roll, and I'm not going to go into what he was doing with pictures, but anyway, they sure would have liked to ban photos, I'm sure. Anyway, that actually has not turned into a lawsuit yet, but yeah.
We do prohibit, but only in the restrooms, locker room, shower areas.
Okay.
That
Yeah, I certainly think if there are certain, obviously the restrooms, things like that, I think that's fair, legitimate. You're not curtailing their ability to engage in discussions or to document conditions at work and so forth. It's just that certain areas where other privacy rights are going to trump those protections to meet and try and unionize. Yeah, Joanna.
We prohibit electronics such as phones, iPods, because it's a distraction for safety since we have high operating equipment.
Yeah.
Vehicles. That's reasonable, right? Not that it's related to privacy, but safety.
Well, and the question is, they prohibit any kind of electronic devices because this is a distraction. If you're operating heavy machinery or you don't want to have somebody who's texting on the side.
Right.
And certainly if you can link that prohibition to some larger business justification, whether it's safety, whether it's privacy rights, federal regulations, HIPAA rights, DOT regulations, I don't want my employees who are driving a semi truck to be texting or whatever. If you can link that prohibition to something like that, I think you're going to be okay. Or if you can't, at least if you limit it to bathrooms, to certain areas where they're going to have less of a right to convene anyway. Okay, I think those are probably the safest ways to do that. Are there other questions about that one? Okay, and that takes us out of the privacy stuff, and now we're into discrimination, harassment, retaliation. Of course, this is always the largest chunk of the legal update, and it's no different this year. The first one I want to talk about is this Alamo, and this is a situation that comes up for a lot of my clients. Okay, you got an employee who's not a great performer, right? She hasn't done anything that's that bad. A few write-ups, it's all pretty minor. She gets pregnant, goes out on pregnancy disability leave, and while she's out, lo and behold, they discover that she's had all these huge screw-ups and she's done all sorts of really, really bad stuff. Okay, and so the question is, what do you do when she comes back? Do you have to bring her back? Now she's a really crummy employee. Okay, what they did is she comes back, yay, I'm not disabled anymore, I'm ready to go back to work, and they said, I'm sorry, while you were gone, we discovered that you did X, Y, and Z, and so you're going to be terminated. Okay, so she files her lawsuit, and what the court looked at is, she actually won, I think, at the jury trial. Yeah, the jury found in favor of her and said this is retaliation. They fired her because she took her pregnancy leave, and so employer needs to pay up. They appealed, and the court said she needs to show that this was a substantial motivating factor. When you have what's called a mixed motive case, we fired her a little bit because she took her pregnancy leave, because we don't like that, but we fired also because she screwed up all this stuff that we discovered while she was gone. Okay, that's called a mixed motive case. And they said when you've got a mixed motive and there is a legitimate reason for why you might have terminated them, the plaintiff needs to show that the bad reason was the substantial reason. This firing was more about the retaliation than it was about the bad stuff that she had done. Okay, I have a lot of clients where somebody goes out on leave, okay, and they bring a temp in, and guess what? The temp is way better than your actual employee. Okay, and so then they say, well, the employee's trying to come back, yeah, and so now we want to keep our temp because our temp is super awesome and great, yeah. They came from workforce staffing, no. Anyway, so this is the issue. Or actually, you get the person goes out on leave, okay, and then you just roll along fine without them, and you realize, oh my God, that person actually never did anything. And so that is typically what comes up. If you're going to terminate somebody right when they're supposed to come back, okay, make sure that you've got some other business justification, okay, to do so. All right, that it isn't based just on the temp is better, okay, because that's not going to be a defense. At any rate, that's that mixed motive, and the Harris decision, which is one we'll get to in a little bit, was one of the bigger cases that we had from last year, and that's where we got that. If you've got one good reason and one bad reason, all of a sudden the burden shifts to the employee to show that the bad reason was the main reason, okay? And so a good case, you know, I'll be back next year to tell you that we have a new law that got rid of the Harris decision, so that's all gone. This Abercrombie case, you know, last year we had an expansion to the religious protections. Okay, they said dress and grooming practices are now covered under religious protections under the Fair Employment and Housing Act. So that what that means is, you know, if your religion says you need to have a beard or wear a certain dress or headscarf or something, you're protected. The employer needs to show that there is some undue hardship to the employer to allow you to engage in whatever that practice is. Okay, it doesn't mean you necessarily get to do it. You know, if I'm standing operating this huge machinery and I want to wear a flowing gown, maybe that's not, you know, good for health and safety considerations. All right, so you just need to engage in that conversation. In this case, she wanted to wear a headscarf. Okay, she worked at Abercrombie, and Abercrombie has this, you know, super cool, they called it their look policy, whatever, where you don't get to wear anything on your head. Okay, and you're supposed to work in the store and wear the cool Abercrombie clothes. And she said, no, I'm gonna wear my scarf. And they said, no, you don't get to. And yes, this goes on 4 months. Finally, they said, you're not following our policy and you're fired. Okay, and she files her lawsuit. And they said, well, is there really an undue hardship? You know, and Abercrombie says, well, this is, you know, sort of our business plan. We have these really cool looking people that work in the store, and then everybody comes and buys our super cool clothes, and this is our business model. This is part of our marketing. This is a major piece of our business. And they said, well, you know, too bad. She can wear her scarf, okay? And part of the reason that they justified that was that she'd been there for 4 months wearing her headscarf, okay? And sales hadn't changed, and traffic hadn't changed, and, you know, whatever. There hadn't been complaints. There wasn't anything that they could demonstrate as to how this was impacting the business, okay? If your only justification for, you know, I don't want them to wear a headscarf or have a, you know, facial hair or whatever the thing is for their religion, if the only justification is, I think the customers might not like it, okay, that's not going to work. That's not going to be enough. All right, you need to really tie it to something to show this is actually impacting us. All right. Was there a question for? Okay. Okay, so there was another, those religious protections really came about, I think, because Disneyland got hit with one. Somebody wanted to wear a headpiece thing, and they said, no, that you need to be, you know, you need Mickey ears or whatever. Anyway, okay, the next one, oh, I liked this one. This is in Iowa. That's that next bullet point down, CRST ban. The EEOC had to pay $4.7 million. You never ever see these. In fact, that's the largest hit the EEOC has gotten. And they said the case was groundless, it was totally frivolous, it was basically just, you know, not good. Anyway, and so you get an idea, $4.7 million, okay? That's what is at stake in terms of the attorney's fees, okay? How costly this stuff can be. So at least in that, you know, I say it's always bad to end up in the legal update. I think this is the only employer that you know, is good that they ended up in the legal update, but you never see those kinds of claims. Typically, though, when we do have big judgments where the, you know, government gets their hand slapped, you can hope that that might signal a little bit of a shift in how we're going to pursue these claims, okay? Because obviously they don't want to have to keep paying that stuff out. Okay, Harris, this is that case I was talking about, that mixed motive defense. I'm not going to go into all that kind of stuff because I already talked about it, but the idea is, you know, you need to show a substantial reason where there's a mixed motive. When that case came out, you know, I did a backflip in my office. I mean, this is a really good, really big case for employers, you know, but, okay, since that decision, we've had a couple of mixed motive cases that have gone up and the employer has lost. In fact, the biggest, I think it's the biggest jury verdict in LA County history, mixed motive case, okay, and the employee won $21.7 million. So it may not be the silver bullet that we were hoping for, okay, but at least it gives you a little something, some ammunition when you go in there. Because generally, you know, if you've got somebody that you're firing, even if they can drum up some discriminatory, retaliatory reason, usually by the time you're firing them, there is also a legitimate reason. Okay, so at least it sort of evens the playing field a little bit. Okay, Kelly v. Merle Norman. I'm on page 23. This first one, employer gets second trial in a sexual harassment suit. Okay, so she files her claim and wins, you know, at the trial level. Okay, and then they appeal and they discover, hey, there was like 17,000 pages of documents that she forgot to give the other side during discovery. Okay, and in those 17,000 pages, it outlines how she's really looking for an excuse of how she can get out of this company, she wants to quit, she hates it here, and blah, blah, blah. Okay, and she just forgot to mention all that stuff. And so they ordered a new trial. The lesson for the employer, okay, all that stuff was on her work computer. Okay, make sure you're checking that kind of stuff. When I get a call from a client, hey, we're getting this claim from this employee, go get that computer, get their cell phone, take a look at what they've been doing. Okay, because there's a lot of potential stuff in there for you to defend yourself with a lot of times. You know, check their Farmville. I mean, are they actually even working, or what? You know, what are they doing all day? UPS. This is another one that highlights those attorney's fees. So the guy wins $27,000, okay? This was a discrimination case. He wins $27,000, and the attorney's fees are $700,000, okay? And that's what, so at the trial level, the attorney says, well, I'm entitled to my attorney's fees, okay, because the plaintiff won $27,000. Oh, here's my bill. And the court said, yeah, that's fine, okay? So the employer appeals, hey, this is crazy, ridiculous. And it was affirmed by the Ninth Circuit. They said that's fine. It was 25 times what he actually won in damages, and that was okay. You know, it's scary stuff. You know, remember that the Fair Employment and Housing Act, okay, has a one-way attorney fee provision. So a plaintiff, an employee who wins a claim that is brought under the Fair Employment and Housing Act, those are the discrimination claims and retaliation and harassment, all that stuff. A plaintiff who wins can seek their attorney's fees to be covered by that employer. Okay, so now you're the employer. Remember I told you there was a new law where you never get to get your attorney's fees covered? Now you got to pay your own attorney's fees, okay, and you got to pay the employee's attorney's fees, and you got to pay the judgment of whatever they want. So there's a lot of money at stake. Okay, you don't want to screw this stuff up. That's why it's far better, you know, call an attorney and get advice before you pull the trigger and fire the guy, or demote him, or, you know, whatever. Harass him, retaliate, whatever you're going to do. I love this case. I couldn't help but put it in. This is not out of California. The Robert Palmer's Simply Irresistible defense. She's a dental assistant, and so he tells his wife that she's this really beautiful dental assistant, and she's an irresistible temptation to him. And so the wife says, you know, well, you're firing her. She's not going to work there anymore. And so he did, and she sued for gender discrimination because she said, well, I'm fired because I'm, you know, this beautiful woman, whatever. And I know. It went all the way up to the Iowa Supreme Court, and the Iowa Supreme Court said, nope, it's okay to fire her. This is not gender discrimination, okay, because it's based on a personal relationship, not, you know, something generic to her just as a female. He's not firing all the females, whatever. This is based on a personal interaction. And so they were able to get away with that. And actually, it's not very nice of her, to her. She is way cuter than this picture. I mean, I don't know if she's irresistible, but that's something to consider. You know, in California, if we've got that mixed motive defense, you know, maybe there is, you know, maybe a legitimate reason would be that you're just so crazy in love with this person. Might not go over well with the spouse at home, but okay. On the next page, I'm at the top of page 24. We have rope. This was an associational disability claim. It's kind of interesting. So you may remember last year, I think, or the year before, we had the Organ Donor Protection Act that went into effect. And it basically says if you're going to donate an organ, you get up to 30 days of paid leave. If you donate bone marrow, you get up to 5 days of paid leave. I stressed it at the time when we were doing our updates because it's a unique law in that it's the very first time that a private employer is being mandated to provide paid leave to employees. Okay, I sort of view it as the first step in a long walk towards providing paid sick leave to employees, which is where I think we'll probably end up at some point. At any rate, this was the first law where the state is telling you, you private employer must provide paid leave in this situation. Okay, so this guy gets the job in like November, I think, and, in September. He gets a job in September, and he tells his employer, yeah, well, you know, in February of next year, I'm going to donate a kidney to my sister, so I'm going to need to take some time off. Okay, so fast forward, it's now December 30th, and effective January 1 is the organ donor law that says if you donate an organ, you get up to 30 days of paid leave. So the guy gets fired on December 30th, okay? And he says, well, hey, I got fired because in a month, I was gonna get 30 days of paid leave, and that's why I was, you know, they didn't wanna pay that paid leave. And the employer said, oh, no, 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 he's this horrible worker, you know, so we worked him right up to the last second, and then we fired him, okay? And what the court said is, look, he was fired before that organ donor law went into effect. Okay, that law is not retroactive. He wasn't entitled to any paid leave. He was fired before that law was in effect. But, okay, they looked at this as an associational disability claim. It's the first time a California court had looked at associational disability. And what they basically said is, if you can show that expense is an issue, that because of your association with this other person, okay, you're going to now cost a new expense to the employer because their medical costs are going to go up, or you're going to get new leave rights, or whatever the case is, based on your association with a disabled person, whether it's your child, your spouse, whoever, okay, you can use that as a basis for a discrimination claim. And so they let him proceed. The lesson here, okay, is when you get a situation that it just smells bad, it's just, you know, it just looks fishy. He's fired 2 days before this law that he's going to really benefit from goes into effect. Courts are going to find a way to work around that, okay? And they did for this guy. And so now really the issue is if you're disciplining somebody, okay, and they can link that to their association to somebody that is disabled, okay, maybe they're trying to get, you know, additional leave under CFRA or under FMLA. If they can link that to something, you may open yourself up to another type of discrimination or claim, yeah. So anyway, an interesting case, just because it was an issue that had not yet been looked at. On the next page 25, US v. Windsor, that was the big same-sex marriage case, okay, and they basically said the Defense of Marriage Act is not good, okay, and the Defense of Marriage Act had said marriage is a man and a woman, and they said that part of the law, we don't get to, that's not fair, okay, it's unconstitutional and we're taking that part out. They left the part that says each state gets to decide for itself whether it wants to recognize same-sex marriage. So what you have now are certain states, like California, do recognize it, and other states don't. Okay, so if you have multi-state operations, you're going to want to take a look at, you know, how this is going to impact you. Okay, because like I said, for FMLA purposes, you have to live and work in a jurisdiction that recognizes same-sex marriage in order for those protections to kick in. For IRS purposes, that's not true. Okay, so, and we're just starting to see how this stuff is shaking out. Actually, if you go to page 27, under in the news, those first two bullet points talk about the FMLA regulations, and then below that the IRS guidance with how we're gonna use, how same-sex marriage is gonna shake out. And the other bullet that I wanted to highlight under here is that fourth bullet down, the race bias suit against Bank of America. This was a $160 million settlement that they got, which is, you know, a large number, but not, you know, so crazy. What I want to highlight about this was that this is a discrimination class action, okay, brought on behalf of a very large class of plaintiffs, okay, and they were able to get over that hurdle of certification. What that means is they basically worked out a little roadmap, okay, for how to get these cases to proceed. We had, you guys might remember that Walmart case where it was like 1.5 million plaintiffs in the class, and the court said, it was Dukes v. Walmart, the court said, this is crazy, this is never gonna work, and they threw it out, and they said, you can't use statistical data, you can't use all this other information, and they basically really hemmed in how you can establish a class for purposes of going forward. Okay, so there was a big hope that, hey, in terms of discrimination cases, we might be able to get out of this, flood of class action lawsuits. And this is the new how to do it guide, okay? And once you get one case where one plaintiff is successful, okay, unfortunately, plaintiff's bar gets to read the update too, okay? All of a sudden, you're gonna see a whole bunch of other people that say, well, if they can do it, I can do it too. I'm just gonna pull up that complaint, I'm gonna scratch out their name and put this company's name in, and I'll file a lawsuit. So I would say watch for that kind of stuff, all right? And what you're really looking for in your handbook, are policies that are applied uniformly that are not good, okay? So make sure you review that handbook. Okay, on page 28, that top bullet, okay, when I say this is big stuff, you don't want the government coming after you, $372.1 million was secured. That's the EEOC, that's just the federal piece. That doesn't count any of the state money and penalties. That's against private employers for the fiscal year of 2013. That's a lot of money, all right? That's money that could have gone to your business, all right? So this is not something you want to monkey around with. I'm going to move to whistleblower stuff. A couple of the things that I just want to highlight. This first one, Davis, okay? This was a person complained, nobody did anything, okay? And now the court says, yeah, you can go forward with a request for punitive damages. Okay, typically you need to show some sort of malicious act on the part of the employer. All right, and here the court said, well, complaining over and over and over again and never having that complaint addressed might be evidence of malice. Okay, and so the question is, did they complain to a person who was in a position to fix it? Okay, and that's what they're going to go back and look at. Typically, if it's like an officer, a director, or a managing agent. Okay, this was a construction project. They had a project manager on site. Okay, and that's who she had complained to. And so the question will now be, did that person have enough authority to trigger that? But the takeaway, don't ignore those complaints. When you got an employee complaining over and over again, make sure you address it. Make sure your frontline people who are fielding those complaints, okay, understand the importance of sending that up the food chain. The next case is this Halliburton. I want to contrast this case with the case on the next page, Marotti v. Marsh. Okay, and these are two cases, it ended up in completely different results, okay, that had the same kind of issue. This first one, Halliburton, kind of interesting. So he worked on a rig, and he lived in Caliente. Yeah, he lived in Caliente. And he would travel to Seal Beach, where his rig was, okay? And they gave him a car. And they had a policy that said, okay, you can drive this company car, you can do some personal errands, but it's basically to take you to and from work, all right? So he finishes his shift, okay, and he drives from Seal Beach to Bakersfield, actually, okay? He's meeting his wife here, they're gonna shop for a new car, they decide not to buy a new car, okay? He gets back in his car and is driving back to Seal Beach. He never even went home. He's now going back to his shift again. He gets in a car crash on the way. And the question was, is this something that the employer is going to be responsible for? Remember, it's a company car. Okay, you would think, I would think, this is something the employer is going to be on the hook for. Okay, they told him he could run personal errands in that car. They gave him the car. It's their car. He's going to work. Okay, and the court said no. This was enough of a deviation in his commute to take him out of the course and scope of employment. Okay, good case, yay. Well, on the next page, okay, you have this Marotti. She drives her own car to work. This is not a company car, it's her car. Okay, she goes to work, but while she's at work, the employer says, hey, can you run to Office Depot and pick up some files? By the way, can you pick up the coffee for the meeting? Whatever. He has her run errands throughout the day in her personal vehicle. Okay, there's an exception, this sort of required vehicle exception. If the employer benefits from that vehicle being at the workplace, okay, even though it might be the employee's vehicle, All right, that's going to take that commute time to and from work and put it within the course and scope of employment. Because the employee, when they get in their own car and they're driving to work, okay, they're bringing that beneficial asset to the workplace for the employer. All right, they get to work, employer says, yeah, now run and pick up the lunch, now deliver these beautiful wreaths that we're giving out to our clients, whatever. Okay, at some point, depending on how much you use that personal vehicle, you put that vehicle within the course and scope of employment. So she's going home now from work. She's actually not going home, she's going to a yoga class, but before her yoga class, she wants frozen yogurt. She pulls in to get frozen yogurt and she runs over a guy on her motorcycle. Okay, and the court said, yes, that is covered. She wasn't far enough away in her commute. It didn't matter that it was her own car. The employer is going to be on the hook for that car accident. Okay? And the legal theory is this respondeat superior, basically. You, employer, are responsible for the torts and the negligence of your employees if those acts happen within the course and scope of employment. Yeah, Joanna?
But she was off the clock.
She was off the clock. She was going home. It was after her shift. These were both a post-shift accident. The guy in the company car that was where the employer was not liable, okay, he's at 140 miles away from his commute. Maybe that's the deciding factor. She was within minutes, okay, but she's in her own car. I mean, it's really, there's no clear answer in terms of how much use of that employee vehicle is going to put the commute time within the course and scope of employment. And there's also not much guidance in terms of how much of a deviation is going to take you out of that, okay, because here she wasn't going home. You know, she wasn't on a road that she typically drove on to get to and from work, but it was still covered. Okay, so be careful. Be careful if you've got employees where you're using their car during the day. Okay, or if you are, just, you know, get a bunch of insurance, and then get a whole bunch more. I think, let me see, we've only got about 1 minute left. On termination, this Moncada v. West Coast, okay, they're getting ready to sell the business. They tell all the employees, just stay on until the sale goes through. When the sale closes, you're going to get a big bonus, you know, as part of the sale, okay? And they stay on, and the company gets sold, and of course, the person who's promised the bonus doesn't work there anymore. They have no control over whether the bonus gets paid, and nothing was paid, okay? So they filed this lawsuit. Lesson is those oral promises, okay? Just be careful with that kind of stuff, all right? Because, you know, what you say and what they hear, not always the same thing, okay? What you say, what they remember, you know, not always the same thing. And you can get yourself into big trouble with that stuff. Nicolette Sheridan, who was our desperate housewife, finally got thrown out of court on her very last claim, so she's going away. And then arbitration agreements, I want to highlight this just because I would encourage all of you, put an arbitration provision in your handbook. The courts have said it's fine that it's in the handbook. That's not going to negate it, even though you probably have a right to unilaterally modify your handbook. That's not going to, you know, render that arbitration agreement unenforceable. There's still a big question as to what you can actually cover in that arbitration agreement. Okay, and that's something that the California Supreme Court's going to rule on this year. The big case is Iskanian. You know, we'll see where it shakes out. It seems like we've got a big division. The federal courts are yay, hooray, enforce the arbitration agreements, and the state courts are no, they're horrible, you cannot enforce them. Okay, and so we've got to make, you know, where those two are going to come together. We'll wait and see, and that's what hopefully the guidance we'll get from that Iskanian case. That's on the bottom of page 35. So those are the big highlights. I have like 2 minutes for questions if people had other stuff. I know it's a lot of material to soak in a single sitting, but be glad you didn't have to read all those cases. Think of it that way. All right, yeah, Joanna.
As we get closer in with Obamacare, are we gonna, or the Affordable Care Act, I mean.
Yeah.
Are you gonna go over that?
Yeah, we'll definitely have more updates as it gets closer. You know, the big key for this year is trying to assess, you know, how many employees you're gonna have. The numbers of your employees this year are gonna dictate, you know, the stuff for next year. What we had, you know, last summer, basically, they said, we're going to waive that penalty phase. We're not going to enforce any penalties against employers. We're going to give them another year to figure out how this is all going to play out. And so it's not really going away, but, you know, you still need to be mapping out what exactly it is you need to do. And as we get closer to January 1, when that penalty phase is going to kick in, you know, that's when we'll start, you know, outlining that kind of stuff. But at this point, there just really isn't much to do, aside from figuring out how many employees you have and providing the notices as you go along. Yeah?
Page 5 on background checks, new law will prohibit a state or agency from asking an applicant to disclose information. That's something that we run background checks because we do a lot, or with a lot of sensitive documents, et cetera. We explain that to the applicant and we ask them ahead of time, is there anything that you would need to explain ahead of time? Is that something that we know of?
Well, this law specifically applies to government employees. If you're a public employer, that's where this is going to kick in. If you're a private employer and doing background checks, and I still advise my clients to do that stuff, have it done through a third-party agency is the best bet. Make sure there's a tie between, they're dealing with sensitive material, they're, going to be handling money, or there's some reason that you need to know that information. If I'm hiring somebody to be a receptionist, I don't need to do a background check on her probably. Okay, if this is going to be my CFO, all right, well, it's a little more appropriate. So as long as you can tie it to where that, and that's where you create that business necessity justification. But that law that you're talking about specifically only applies to government employers. And they didn't say you can't do it. They just said you can't do it in the beginning of the employment process. You have to do it, down the road. Are there others? All right, thank you. You guys have been a very good captive audience.